Matters before the court on the defendant's motion to enforce and modify child support.
I never received any support, nor I can even dig my stuff. So life is just like a nightmare with two young kids.
So are you saying that there is no support order at the current time?
The children live with me full time. Miss Parr only sees the children for an hour a week. She pays me child support.
As Mr. Spring states, there's an order for requiring you to pay child support. So it wouldn't be appropriate for you to enforce the order because all you have to do is pay the support. I've read all the pleadings in this matter. Ms. Parr, I don't quite understand. You said that this order was entered back in 2017, and I don't understand why it would take 4 to 5 years for you to correct any inaccuracies that you stated occurred, basically 5 years ago. And
the case opens with a motion to enforce and modify child support, but clarity is missing from the very first exchange. One parent claims years of financial struggle and no support, while the court immediately questions why alleged errors from 2017 were never raised until now. From the start, the judge signals concern about delay, credibility, and the purpose of being here today.
Again, the allegations that you make as it relates to the referee do appear to be fantastic. So I'm at a loss as to what you're alleging.
Your Honor, I was very weak after threatening some kind of narcissistic abuse that for so long, and I was afraid to bring things up. And every time I have a attorney, they told me not to, and now I was alone, and I think that's the only way that the court can see things clearly.
Okay, so what's the basis for your motion?
The judge presses hard for the legal basis of the motion, not emotional history. Claims of fear, abuse, and past silence are raised, but the court redirects repeatedly, asking one simple thing: what law supports this request today? The gap between personal suffering and legal standards becomes painfully obvious as answers drift without landing.
As the law said, when there's an existing case, everything has to be filed on the existing case. Instead of this case, they just come up with a new case without the court involvement and take over the old case. And when I was suffering financially to taking care of my kid.
Okay. Well, this case was consolidated back on February 5th, 2018. And that's not unusual that if you got, a support case and a different, like in this case, the DC case, the cases were consolidated. That shouldn't impact the case at all because you can still make any corrections that need to be made. So again, I'm still not understanding what you're asking for.
I am asking for, Your Honor, because of all 2 years unpaid child support.
The issue of consolidation is raised with accusations that cases were merged improperly years ago. The judge explains this is normal and does not erase existing orders. Corrections could have been requested long ago. This moment underlines a hard truth of courtrooms. Procedure matters more than perception, and missed chances rarely revive themselves.
That's what I wasn't able to come up with money to hire an attorney to presenting me until everything went downhill.
Okay, that still doesn't tell me what's the basis for your motion. You're saying you didn't have money to be able to fight it at that time. That's understandable, but it doesn't tell me why we're here today and what the basis is for enforcement or modification.
Well, they consolidated without the court involvement of February 5, 2018, but does not include the support order. I take the attachment. They cross out with a pen. And because of that, I never received any support, nor I can even dig my stuff. So life is just like a nightmare with two young kids, and to still affect the case today.
So are you saying that there is no support order at the current time?
Mr. Spring explains the support order clearly. The children live with him full-time, visitation is limited, and the support order was court-imposed, not voluntary. Suddenly, the picture sharpens. The court confirms that the obligation runs in the opposite direction than claimed, weakening the motion's foundation almost completely.
No, Your Honor, that order has been finalized on December 2017, but I does not receive a penny since the day you entered the final order, Your Honor.
Well, maybe I can get Mr. Spring. Maybe you can enlighten me. What's happening if you know?
He probably know because I am not aware of.
Okay, I've turned it over to him. I want to hear from him. So, Mr. Spring, enlighten me what's happening.
We've gone through several evidentiary hearings with the front of the court, and this is a support order that was put in place by front of the court, not by any agreements or anything like that. So this is just the state putting this order in place. The children live with me full time. Ms. Parr only sees the children for an hour a week supervised. So she pays me child support, and that's it. There's nothing other than that.
Ms. Parr, is that your understanding that the support order basically obligates you to pay support? You are the support payer?
In the DC case, yes, Your Honor. But in the DS case, you awarded me full custody of both the minor children until the DC case come out in 2018. And then Mr. Spring just start setting a trap with me. All witnessed by the minor children. I attach all the police report as well. He against me in PPR with false police report.
Accusations escalate. False reports, traps, mediation pressure, loans taken to survive. The judge cuts through it firmly, stating none of this establishes a legal basis for enforcement or modification here. The ruling lands decisively. The motion is denied. Courts do not run on chaos. They run on authority and evidence.
And then that's how the DC case come out with the court, without the court involvement. And also in May 2023, 2018, they told me we have meditation at your courthouse. And I was there, witness with Marco from the safe place. They told me if I did not sign a halfway cut down the child support amount on the DS case, on the DC case, I will never receive a penny. And that time I already took 10,000 personal loan just to buy everything needs for my kids. And
Okay, ma'am, try to focus on the motion. You filed a motion for enforcement and modification of child support. I don't need to get into all that extraneous stuff. I just want to know what's the basis for your motion.
Everyone should obey the court order, Your Honor, and this is the order still alive because they did not consolidate with the DHC case. They only consolidated the custody case. You can see that they cross out with a pen.
Well, in this particular matter, the only thing I could suggest, Ms. Parr, is that you proceed through this matter with the front of the court and see if you can't straighten out, again, the consolidation and the other, because quite frankly, as I look at this matter, as Mr. Spring states, there's an order for requiring you to pay child support, so it wouldn't be appropriate for you to enforce the order because all you have to do is pay the support. There'd be no issue in that regard, and apparently the front of the court has not pursued any action in this matter as well to enforce the order. So I'm really, as I stated, I'm at a loss as to what the situation is in this particular matter. So all I can say is you might want to proceed with the front of the court, as they have obviously involvement in both cases, the DS and the DC case in this particular matter. So the court just doesn't find a basis for the motion at this particular time. So I'm going to deny that motion. Mr. Spring, I'll ask in this matter that you would prepare an order denying the motion. And you can submit, if you submit that within 7 days, you can do it without having a hearing. And if you don't, then you're going to have a hearing to get the order entered, okay?
Okay.
Thank you. The court will end this matter at 10:49 a.m. You're free to go. Have a good day.
The plaintiff, he is alcoholic and there's ongoing sustained alcohol abuse to the minor children, and he don't take them to counselor once or ever. So this can affect their mental seriously. It can be like a long time.
Counsel withdraws without opposition, and refund demands are dismissed as irrelevant. The focus shifts to a new motion seeking custody and support changes. The court listens but quickly recognizes a familiar pattern. Old claims are being recycled, not replaced with new facts that meet the legal threshold.
Court will note the appearance of Ms. McIntyre on behalf of the defendant. We have two matters before the court. The first is Ms. McIntyre's motion to withdraw as counsel for defendant, and thereafter defendant's motion to modify custody, parenting time, and support. We'll take, Ms. McIntyre will take your motion first. It's my understanding, based upon the pleadings, that the defendant is not opposed to your withdrawal. Is that correct?
That is correct, Your Honor. And this court previously actually ordered that I was to withdraw. And I think that there was a delay, or the paperwork got lost when I submitted the order under 7-day. And so that's why I had to renotice it out. But the court has already granted that request.
Okay. Ms. Power, are you opposed to the motion to withdraw?
Yes, she just don't do anything, so there's no point her in the case. I just need she refund at least a couple thousand.
Okay, well, that's not before the court. Her motion is to withdraw is before the court. All that other stuff is stuff you'll have to take care of separately. It doesn't involve the motion to withdraw. So the court will grant the motion to withdraw. And Ms. McIntyre, do we have an order in the file now?
Yes,
Okay.
you do.
We will get that entered, and then you are able to withdraw at this point. And if you wish to leave, we'll proceed with the defendant's motion.
Okay, thank you, Your Honor.
Thank you. Have a good day.
Thank you, you too.
Ms. Power, we'll proceed now with your motion for modification of custody, parenting time, and support. Go ahead.
Well, the kids are basically is in a very, very bad situation right now. So they really need to come home. The court need to look into the deeper how everything went just some kind of upside down. And they need to be a loving home. They need to be cared. They deserve everything. So there's a lot of allegation like sexual abuse, physical abuse. They all are attached with the motion.
Okay.
And also the plaintiff, he is alcoholic and there's ongoing sustained alcohol abuse to the minor children, and he don't take them to counselor once or ever. So this can affect their mental seriously. It can be like a long time.
Anything else that you want me to consider?
Can they come home, my kid?
Well, I'll ask Mr. Spring, do you have any response to the motion?
I would like this to be rejected. The situation with their mother has not changed, so I don't think that there should be any change in the custody order.
The judge explains that repeating past allegations does not trigger a new hearing. Without fresh evidence showing a true change in circumstances, the court cannot act. The motion is denied again. This case ends as a reminder that courts require precision, timing, and proof. If you found this breakdown helpful, like the video, subscribe to the channel, and we'll see you in the next video.